Hello, this is a training video commissioned by the Immigration Advice Authority. My name is Julian Bild. This video has been designed to cover all levels of trafficking work, but trafficking work is difficult, and watching this video does not qualify you in any way to work above the level that you're registered. Okay, if you do want to do trafficking work, you'll need to get to level 2. Okay, so trafficking work is always complex, but on the flip side is fantastically interesting. Okay, so if you were purely doing trafficking work, this isn't work regulated by the IAA. So the biggest group of victims of trafficking in the UK are British citizens who don't have, obviously, an immigration case. But if your client does have an immigration case, and the fact that they may have been trafficked to or within the UK is relevant to that case, then you will need to be at least level 2 qualified. So this is complex casework. I'm going to take you through a PowerPoint presentation. Okay, I'm not exactly sure how this, sorry, scrap that. Drew, I was going to say. This course has been designed to provide you with an overview of trafficking in an immigration context. Okay, and at the end of the course, we'll provide you with some links to resources where you can find some more information. Okay, so a short webinar identifying the basics, okay, and then linking you to a lot more information if you want to do trafficking work. Okay, so we're going to look briefly at who is a victim of trafficking and modern slavery, the UK's system as part of the Home Office for identifying and supporting victims of trafficking, the National Referral Mechanism, the decision-making process within the NRM, so a decision-making process in 2 stages to identify whether someone initially may be a victim of trafficking and then to make a further decision on whether they actually are a victim of trafficking. How to challenge negative decisions, working with victims, the support available for victims, public order disqualification from the NRM for those with criminal convictions, specific immigration issues that arise in the context of a trafficking claim, so specific bits of the immigration rules allowing victims of trafficking in some circumstances to extend their stay in the UK for a little bit. So we'll look at Appendix Temporary Permission to Stay and Appendix Domestic Worker who's a victim of modern slavery. Briefly at the Immigration Variation of Leave Order, which provides 3C continuing leave for some of those who enter the NRM. And we'll look briefly at human rights and asylum claims involving victims of trafficking. We'll also look at the availability of legal aid. So what is human trafficking? The basic definition is provided in the Council of Europe Convention on the Action Against Trafficking in Human Beings, which we often call ICAT. Okay, so this is a convention which the UK has signed up to, and the European Council has nothing to do with the European Union, so we're still very much a signatory to this convention and bound by the duties that we've signed up to. And it's Article 4 of this convention which defines a victim of trafficking, okay, as someone who's been subject to an action by their traffickers, by a means to achieve their ends for the purpose of exploitation. So this is often reduced to or expressed as a 3-stage legal test requiring an action, a means, and a purpose, or action, means, and exploitation. Okay, so someone will be trafficked by someone. The trafficker will use a means in order to control that person and for the purpose of exploitation. Okay, means is not necessary for a child victim. Okay, so a child might be particularly susceptible to exploitation. An adult might go to a child and say, do this so that I can exploit you. And the child says, okay, then, because they're used to doing what they're told. So there doesn't have to be that, there almost always will be, but there doesn't have to be that physical threats, abuse of power, etc. You will often see those means being used in respect of children. Okay, but the process of grooming a child might just be to offer them some inducements. Okay, so to be fair to children who are victims, they only need to meet the action part of the definition and the exploitation part. And the exploitation doesn't have to have happened yet. It could be that someone is fleeing an attempt to exploit them. So they may have been brought to the UK for sexual exploitation, but have escaped their traffickers before that actually happens. It's not smuggling. It's often confused with smuggling. The word trafficking is often used interchangeably with the word smuggling. But smuggling is paying someone to bring you here, and the relationship with them ends when you arrive. Trafficking always involves that ongoing exploitation after arrival or after movement, if you like. Okay, so smuggling and trafficking can be interlinked. People can be trafficked by their smugglers. Okay, but smuggling per se is simply an arrangement for someone to be delivered to the UK, and that doesn't necessarily involve exploitation. The trafficking may be historical. Okay, it might have happened in someone's own country, but they've escaped to the UK, or it might happen on the way to the UK. So we see a lot of people fleeing North Africa who end up being exploited in Libya and then escaping from exploitation and making their way to the UK to claim asylum. Okay, so the trafficking can have happened in someone's own country or a third country or on the way to the UK or in the UK or in all those places sequentially. Uh, what is modern slavery? So this is a broader concept, really coming out of much of the work that Theresa May was doing around trafficking when she was Home Secretary and then Prime Minister. But it can add some confusion. Okay, so modern slavery is an umbrella term that includes trafficking, action, means, and purpose. It includes slavery. Okay, it includes servitude. Includes forced or compulsory labor, all of which have their own definitions under various international conventions. Okay, but generally speaking, we're looking for the definition of trafficking to be met, and perhaps some of these other definitions serve only to confuse things. Okay, but be aware of them because there may be situations, for instance, where your client has been coerced into being exploited, but there's no obvious movement there. You know, they're being exploited in situ, so there hasn't been an action as such. And it may be difficult to meet the full definition of trafficking, but possible to meet the definition of slavery, servitude, or forced or compulsory labor. So it can be helpful to understand these definitions. Okay, and they're further defined in the main document that we'll need to consider if we're going to be helping victims of trafficking, and that's the Modern Slavery Statutory Guidance, so a very lengthy document. Okay, that further and usefully defines many of these terms. Okay, so I've just included some examples from my casework of victims of trafficking that I've represented. So quite a lot of asylum seekers, probably most asylum seekers coming through Libya, will have had some very horrible things happen to them there. Okay, so often being tortured at the hands of criminal gangs, okay, and often being exploited in fields, in battles, in warehouses, in factories, and sometimes simply tortured so that their families will pay for them to be released from that. Okay, so it's probably worth exploring with any of your asylum seeking clients that have come through Libya what their experiences were there. And the advantage of being found to be a victim of trafficking in the main is that you get more support in the UK whilst your asylum claim is being decided. Okay, so the main advantage of going into the NRM is that they will support you, help you recover from your trafficking. Okay, and the decisions made by the NRM may support your asylum claim. Okay, if they identify vulnerabilities, including exploitation that you've suffered, that may form the basis for an asylum claim or may be significant within an existing asylum claim. Okay, so those representing asylum seekers from Africa should be aware of that. Many people, usually young women, but it can be men, brought here to be sexually exploited in brothels. Probably the biggest group of those in the NRM are young British citizens who have been groomed into distributing drugs. Youngsters, often from Vietnam or Albania, brought here to work in cannabis grows. People coming often from Southeast Asia, but from any part of the world, often brought into the Middle East to be domestic workers for Middle Eastern families, and then brought to the UK as domestic workers by those families. Those trafficked into agriculture and factory work. You know, my experience, I'm sure this happens everywhere in the world, and everyone is at risk of being exploited. But those exploited for agriculture and factory work were often or are often vulnerable people coming from Eastern Europe. And there's lots on the internet, and I've given you a couple of links to show statistics where particularly victims of trafficking are coming from and the main types of claim that we see. Okay, this is a very much a non-exhaustive list. People are always finding different and new ways of exploiting others. So we have in ECAT, where we saw the definition at Article 3, duties to identify, provide support and assistance to possibly allow victims to stay in the country for a little while to recover and provide them with compensation. Okay, so where I used to work, ATLU, we used to do a lot of compensation work. That was sometimes taking their employers or traffickers to court, but it sometimes involved making applications to the government under the Criminal Injuries Compensation Scheme. Underpinned by Article 4 of the European Convention of Human Rights, so the prohibition on slavery, and again, looking at it through a human rights lens rather than through the Convention Against Trafficking, We see again the duties placed on governments within the Council of Europe, including the UK, to have systems to implement measures to combat trafficking, to protect victims, and to investigate potential trafficking. And those duties under Article 4 brought into domestic legislation by the Human Rights Act 1998. Further sources of law, well, if you like, our duties under Article 4 and under Article 4 of ECAT and under Article 4 of ECHR, all brought into play within the framework in the UK, the NRM, okay, governed by policy, underpinned to an extent by statutory law, but governed largely by policy, which you will see in the modern slavery statutory guidance. So that's going to be your key resource, okay, when learning about trafficking work and representing your trafficked clients. That's regularly updated, and we can see the latest version dated from the middle of last month. So we have definitions in the statutory guidance, how victims are identified. So it's a very important concept of indicators. You know, your client may or may not be able to express what they've been through, but they may be objective indicators of how they've suffered, quite apart from what they've told you about their circumstances. The roles of various agencies to support and protect victims of trafficking. So, for instance, local authorities or the Home Office, who comes across victims of trafficking in their normal work. How the National Referral Mechanism works, how it provides support or how much support it provides. So money and accommodation sometimes, provision of a support worker, access to NHS care, etc. So that detailed support set out in the appendices to the modern slavery statutory guidance, and both the decision-making process, the initial reasonable grounds decision, the final conclusive grounds decision, how you challenge negative decisions, okay, and where you've been given a positive conclusive grounds decision so that you are recognized as a victim of trafficking, the onward support available to you to ensure that you're safe. Further sources of law, specific provisions within the 2022 Act that reduced the minimum recovery period for those who have a positive RG decision from 45 days in England and Wales to 30 days. It introduced the power for the government to disqualify people from protection and support on public order grounds, and it narrowed the basis on which leave to remain is granted for victims of trafficking. Okay, so the 2022 Act, that's fed very much into amendments to the modern slavery guidance and to the new appendix victim of trafficking arising from the 2022 Act. So trying to remember the date, beginning of 2023, appendix victims of trafficking, replacing the discretionary leave policy, which was granted on a more generous basis. Okay, and the specific bits of the immigration rules, specifically aimed at those found to be victims of trafficking, appendix temporary permission to stay, appendix domestic worker as a victim of modern slavery. Okay, we'll refer to one or two other bits of important guidance, particularly on those immigration routes, but also relating to ongoing support needs after someone gets a CG decision. So there's just a couple of other documents that we'll be referring to in this presentation. So what is the National Referral Mechanism? Well, in practice, it's a few offices full of people sitting somewhere in the Home Office. Okay, it's a framework for identifying, referring and supporting victims of modern slavery in the UK. Okay, only staff at designated first responder organisations can refer into the NRM. So there's a statutory process which involves a first responder completing an online form, providing quite a lot of information about the potential victim in order to get the NRM to look at their case, to decide whether they're a victim of trafficking, and to support them in the meantime. So this is what we refer to as the referral mechanism. If we come across clients who we think may be victims of trafficking and who would benefit from the support provided by the NRM, we can't, as advisors, make that referral ourselves. We have to first refer to or signpost to a first responder organization. Okay, and particularly that might be the police, for instance, it might be the Home Office. Okay, but if you like, the overarching contract for this work has gone to the Salvation Army, and both the Salvation Army and an organisation in Bristol called Unseen, a charity that looks after victims of trafficking, both of them have 24/7 helplines so that they can contact those organisations who will then make the referral. Okay, sometimes those organisations will say they don't have the resources to do so. They will say they're not funded by the government as first responders, and they will say go somewhere else. Well, that might be necessary. You may struggle to find an appropriate first responder. Okay, but if someone has an immigration case, you know, the fallback position is that you can require the Home Office to act in that case as first responder and themselves refer that person into the NRM. Okay, and particularly with those claiming asylum, there's a specific question in the asylum screening interview: have you been exploited? And if the person understands that question and gives a positive answer, the Home Office should themselves make that referral. Okay, so there's a list of first responders in Annex C to the guidance. Okay, and as soon as a first responder has been notified that someone's a potential victim of trafficking, they will have safeguarding duties. Okay, and if someone needs immediate safety, it will be the responsibility of the police to ensure that they're safe, or if they're vulnerable to re-exploitation because, for instance, they're destitute, then the Salvation Army will be able to provide them with immediate support, money and accommodation to ensure that they do not enter or re-enter exploitation. Okay, be aware though that some of the people you come across may be currently being exploited and need help to escape. And then it may be the police that do that. Okay, or there are a number of charities. I'm very involved with a number of charities who specifically will rescue, for instance, exploited domestic workers themselves if necessary. Okay, so be aware that your client might be themselves being exploited when you meet them, and that you'll need to think of your safeguarding duties to ensure that they are provided with safety. Okay, so adults must consent to being referred in. So, of course, you will discuss this with your client before you signpost them or refer them to a first responder. But child victims don't have a choice. If they're identified as someone who might have been trafficked or be at risk of trafficking, then usually the local authority will make that referral without needing to get the consent of the child. Okay, and when the referral is made, there will be two bodies within the NRM making the decisions, the identification decisions, the RG decision, the CG decision. They will be the single competent authority, which is no longer the single competent authority, because there's also an immigration enforcement competent authority. So there are two competent authorities. And the IECA is likely to be dealing with your clients if they have a current immigration case being looked at by the Home Office. So particularly those who are removable or detainable or have a claimed asylum or are in part of the enforcement machinery, it's more likely that their case will be directed to the IECA rather than the SCA. Immediately on referral, the individual might be entitled to immediate help if they're at risk. Okay, will be entitled always to emergency NHS care, and from that date onwards cannot be removed until they've been exited from the NRM at the end of the process. Okay, so once you're in the NRM, you're entitled to have the support, you're entitled to have those decisions made, RG, CG, okay, and you can't be removed during that process. Okay, at the end of that process, you may be exited from the NRM, and only then will your protection from removal be lifted. Okay, so a case there that says that the need for protection and support can happen from the moment that the authorities have been informed there's a risk of trafficking. Okay, so although the normal process is that you get your RG decision before you get the support, you may need the support before that. So two-stage decision-making process. Initially, the reasonable grounds decision, which should be made within 5 working days of the referral. Okay, so you'll see the test that will be applied. The competent authority will have to decide if there are reasonable grounds to believe, based on all the available general and specific evidence. So general evidence about trafficking, about the country that your client comes from, and specific evidence about what's happened to them. Okay, so reasonable grounds to believe, but falling short of conclusive proof. So conclusive proof is on the balance of probabilities. So this is a lower standard of proof. Okay, so reasonable to believe, perhaps again something approaching the lower asylum standard. Okay, now once they've got a positive RG decision, most of those referred into the NRM get positive reasonable grounds decisions. They will be allowed a recovery period of at least 30 calendar days. That's sort of not a particularly important number, even though it's been reduced from 45 in the 2022 Act. It's not a particularly important number because someone will receive the support they need until they get their CG decision and until they're exited from the NRM. Okay, now, when I was doing trafficking work, and that was only a year and a half or so ago, the NRM was taking up to 3 years to make a CG decision. So that's provided that person with 3 years of support. Okay, but there's been a considerable reduction in the backlog so that decisions are being made, conclusive grounds decisions are being made within a month or 3 of referral in. So much less time to get your act together, an advisor, and prepare your client's case. Okay, so the RG decision is the entry point into the NRM, usually for those that need support. Okay, and the support they then get will last until they're exited. Okay, but that will be a minimum period of 30 days. Okay, they'll have access to legal aid for immigration advice. They will have access anyway because asylum, protection, domestic abuse is in scope. Okay, so if they're asylum seekers or victims of domestic abuse, as well as being victims of trafficking, they will have legal aid because their cases will be in scope. But once they've got an RG decision, any other application for leave or permission will be in scope. Okay, so they will be able to make Article 8 applications on family and private life grounds, for instance, or trafficking applications under the relevant appendices. So having an RG decision brings, in effect, a whole number of immigration applications into the scope of legal aid, whereas they would not have access to legal aid without that decision. Okay, access to government-funded support. So the government subcontracts with various organizations to provide support. So it actually contracts to the Salvation Army, which subcontracts to a number of organizations, charities who specialize in supporting and protecting victims of trafficking. Okay, so post-RG, that person will be allocated a support worker who will help them navigate their lives, help them find legal representation, etc., help them access counselling, medical services, perhaps some training, some studies, some things to occupy their time whilst they're waiting for a decision. Okay, so legal advisors will be well advised to get on with the support worker, because if you're working and liaising with your client support worker, it's going to be best for everyone. Okay, so support workers can be fantastically helpful points of contact for the casework you're doing for your client. Accommodation, material assistance, so they'll get some money and it will be paid at a higher level than, for instance, asylum support. Access to translation interpretation services, access to counselling, advice, etc. Now, of course, we know that all those things are in short supply, so it's not easy access to those things. Okay, but the support worker's role is to do their best to get people the protection they need and the support they need to recover. And then, importantly, access to the NHS. They may have that anyway if they're an asylum seeker, but otherwise probably not. They will not only be able to access NHS secondary healthcare services, which are usually charged for, but they might be able to get any bills outstanding written off. Implications of a negative RG decision, well, you'll come out of the NRM and lose any support to which you're being entitled, but you can apply for reconsideration of that decision. If you get a positive RG, the NRM will move on to the conclusive grounds decision. Okay, so you'll see that will be 30 or more days after the RG decision, and at that stage, the NRM will be determining on the balance of probabilities whether you are a victim of trafficking or not. Okay, we're going to point you to lots of useful resources for your trafficking casework at the end of this presentation. But suffice it to say, in order to get a positive CG decision, you're going to have to do some casework, and that will usually involve, at a minimum, preparing a detailed statement of your client's case and why they've been trafficked. Okay, so 14 days of move-on support, where you get a negative CG decision. Again, you can challenge that decision. A positive CG decision, so at the end of that process, there'll be an automatic consideration as to whether you're entitled to temporary permission to stay or not. And you'll get a minimum of 40 days move-on support, so they will continue to support and protect you for 45 days. If you need more than that, okay, you can ask for more from your support worker, and the NRM will consider whether you need further support and protection under what's called the RNA process, and we give you the guidance, the Recovery Needs Assessment process. Disqualification from protection, this is complex, but I don't need to say anything more about this at the moment because the Home Office has suspended this process due to litigation, a number of courts deciding that people shouldn't be disqualified from protection in the circumstances that the Home Office have been disqualifying them. So the Home Office, the NRM, has taken a step back, currently suspended disqualification. So a slide there about reconsideration of negative identification decisions and a reference to the details of that reconsideration process in the statutory guidance. So have a look at that. You can challenge that decision either on the basis that there's been a problem with the decision-making process, it hasn't complied with the statutory guidance, or because there's new evidence available. 30-day deadline. Again, something that's a little bit contentious and something that the courts are looking at. Okay, but get that recon decision in, recon application in on time. You're given a 30-day deadline. If it's impractical to do that for very good reasons, you would seek an extension of that time from the NRM. Temporary permission to stay. Now, this is not a settlement route, and in fact, very, very few people are granted permission to stay on this basis. But you can see potentially it's possible to get a little bit of permission to stay in order to recover from your trafficking experiences if you are receiving treatment, in order to seek compensation here, and in order to cooperate with the public authority, usually the police or the CPS. But even if you have those needs, you will not get permission if the Home Office decides that those things can be done from abroad. So you can continue to pursue your compensation claim from abroad, you can continue to cooperate with the police from abroad, and you can access counselling or other health services abroad. Okay, so you'll see there's specific guidance on seeking temporary permission to stay. Where grants are made, they're usually very short and very difficult to get extensions. Okay, you can't, for instance, get VTS, temporary permission to stay as a victim of trafficking, because you have protection needs. The route for your protection needs to be acknowledged is a protection claim. Okay, no need to apply for the first grant of VTS. That will be considered automatically following a positive CG, though it would help your client if you can do a bit of casework to establish their needs and to show that they can't get that assistance abroad. Okay, so in order to get VTS, almost certainly that will involve you in some casework. And because your client has a positive CG, they will be able to get legal aid for that work. Okay, just a process of seeking reconsideration of a VTS refusal, no right to an admin review, no right to appeal, but there is a reconsideration process. Again, if you think the Home Office hasn't followed their policies or where you have new and better evidence. Okay, your client might be seeking protection in the UK. All or part of their protection claim may involve trafficking. Okay, of course, these protection regimes are forward-looking, so they will have to establish that they are at risk of re-trafficking again. But a very important principle in protection claims is that you have been persecuted, and trafficking will be persecution. If you have been persecuted in the past, that's the best evidence of a real risk of further persecution going forward. And we provide you there with essentially a outline of a very important case in the upper tribunal, HD, which looks at the circumstances in which someone may be re-trafficked. And we're not here generally looking at someone being re-trafficked by their traffickers, i.e., you've escaped from me, if you come home, I will exploit you or punish you. Okay, that might be possible, but it's going to be quite difficult to establish if your trafficker's just one person. Easy to establish if it's a large criminal network. But more often, if a vulnerable person who has been trafficked is going back to the circumstances from which they have already been trafficked, and now they're going to be all the more vulnerable because of their trafficking experiences, then you will be able to argue they will be at risk of re-trafficking, not necessarily by the people who trafficked them before, but because of their circumstances, because of their vulnerabilities, the risk that they may be trafficked by someone else. Okay, and because victims of trafficking have been through extraordinarily horrible experiences, they may find it very difficult for all kinds of reasons to give an honest, detailed, and consistent account of that at the various stages at which they will be asked questions. And that's acknowledged in some very good case law, such as this extract from MN and IXU, where it's acknowledged that people do lie. It doesn't mean they haven't been trafficked, or their accounts are quite garbled or inconsistent. Okay, it might indeed actually be evidence of the problems they've faced in the past if they're unable to give a detailed and consistent account. Okay, so they're very useful case law on this specific issue, which you can quote in your representations. The last few slides, and we don't have very much time to look at these, are relating here to the 2-year extension of stay that an overseas domestic worker can apply for if they get a positive decision. So rather than the discretion under Appendix VTS, they have as a right as an overseas domestic worker to a 2-year extension of their visa so that they can continue to work as a domestic worker in the UK. Okay, how the application is made. Okay, then the variation of leave order, which is not well known about, but it does mean that if you're an overseas domestic worker who goes into the NRM whilst you still have leave, then going into the NRM itself acts as a type of continuing leave, so that in those circumstances, the domestic worker could continue to work whilst they're in the NRM. Okay, great to work with victims of trafficking, but also you must recognize their vulnerability. You're going to have to get to know them well in order to get the best from them when you're drafting their statement. And here we're simply pointing to the Trauma-Informed Code of Conduct from the Helen Bamber foundation as an excellent guide in how you work with traumatized clients and how you get the best out of them. Okay, some pointers towards doing that. Okay, some pointers towards the statement that you will draft. Okay, it's likely to be long because it will need to go into detail into your client's background. Okay, so it's not just the events that are relevant. Okay, it's their background. How did they get into that position? How have they acquired their vulnerabilities? Okay, and then that statement will be useful not just to get them a positive CG decision, but also to help them with any protection needs they might have. Okay, and because that statement is such a key part of your casework, I've given you a link there to the @Hub website, which has been developed by the organization I worked for, the Anti-Trafficking Labour Exploitation Unit, which is the only law firm in the UK which specializes solely in trafficking work. We give you a lot of advice there about how to draft your client statement. Okay, we also know that victims of trafficking may have multiple issues, and we might need to have to refer people to lawyers with other specialisms. Okay, so criminal solicitors, sometimes to challenge convictions, community care and housing solicitors for support issues, employment lawyers for challenging exploitative employment relationships, and to seek compensation. And to finish the presentation, I hope you feel you've got something out of it. Okay, we've given you some links to some other very useful information from ACLU. They have 2 websites, chock-a-box full of very helpful casework tips. Okay, and we give you some important links there. I hope you've enjoyed the presentation. Goodbye.